Welcome to Legal One School Law TV. My name is David Nash. I'll be your host for this program. I'm the coordinator for the Legal One program. We're very excited to bring you this program, which will provide timely information on the latest developments in school law that all New Jersey school districts should be aware of. In this initial episode, our premiere episode, we're going to be discussing a number of key issues. We are going to talk about TeachNJ, the latest reform in evaluation and tenure law for the state of New Jersey. We're also going to talk about the latest developments in the area of bullying and the new grading system that the state of New Jersey is putting in place for all school districts. We're going to give you information on Section 504 and the latest guidance put out by the U.S. Department of Education regarding student athletes who may need Section 504 assistance. We'll also provide you with information on school security and the latest information that's come out that school districts need to be aware of on the issue of school security. Our first issue is tenure and evaluation. TeachNJ, New Jersey's tenure reform law, as we know, imposed major reforms in the area of evaluation. These reforms are very significant. They include a number of sweeping changes. We have a great deal of information available for you on our website that addresses these important changes. Viewers should know that there are now a number of decisions that have come down under the TeachNJ Act. The new act includes arbitration decisions. In the past, these cases were all decided by administrative law judges and then reviewed by the Commissioner of Education. We now have decisions that are coming forth decided by arbitrators, and we give you the link to this information on our website. Viewers are encouraged to review the initial decisions that have come out regarding this law. There also are new regulations that viewers should be aware of regarding TeachNJ. Some regulations were adopted by the New Jersey State Board of Education in February 2013. A new set of much more detailed sweeping regulations were proposed at the March 6, 2013 Board of Education meeting. Those regulations are scheduled for final adoption in September of 2013. Viewers are encouraged to review information available on this website regarding those proposed changes in New Jersey regulations. Another important issue that is under review, of course, is the issue of bullying in our schools. We want viewers to be aware of a major recent case that was decided regarding the issue of bullying in our schools. This case involved the Tenafly School District. The case involved a young fourth grade girl who came to school. Unfortunately, the girl was identified as having lice. Another student in the class ended up singling this girl out, and the student ended up being ostracized and bullied because of her condition, because she came to school with lice. In this case, the school district did a thorough investigation, determined that the little girl had been bullied, and there was a legal challenge to this decision. It was a very important case because in this case the Commissioner of Education decided that a girl who's being singled out because she has a condition such as lice is somebody who is able to have the protections of New Jersey's bullying law. That was considered a distinguishing characteristic that would allow somebody to be protected. That decision shows how broadly New Jersey does define the key aspect of the bullying law, whether or not there's a distinguishing characteristic that motivates somebody to single a person out as a victim. Another important development on the issue of bullying is a report that was released by the Bullying Task Force. That task force is chaired by the NJPSA Executive Director, Patricia Wright. The task force came out with its first initial report regarding the issue of bullying and its first set of preliminary recommendations. Viewers are encouraged to review the full report that's available on our website and are encouraged to look for ways to participate as the task force seeks additional input and looks to develop additional recommendations in the coming months. Another important issue that has come up on the issue of bullying is the grading of school districts. Under the Anti-Bullying Bill of Rights, the New Jersey Department of Education is required to issue a grade for every school in the state of New Jersey and for every school district on how well they're doing in implementing the new bullying law. The Department of Education has now released guidance on how it will go about doing this. The system is effectively going to be a self-assessment system where school districts are going to use a rubric developed by the state of New Jersey to grade themselves on a number of key indicators. The self-assessment will initially cover the period from the date the law was signed, January 5, 2011, all the way through June 30, 2013. School districts, as part of this self-assessment, are going to have to give themselves a grade in 8 different core elements. For example, the self-assessment covers training, it covers curriculum, investigation procedures, reporting procedures, and a number of other key elements. The maximum score that a school will be able to receive under the new grading system is a score of 75. When schools do develop their grades, they're going to have to put the information out for the public to comment on, and the Board of Education is going to have to give final approval to the grading for each individual school. Importantly, the New Jersey Department of Education also has the ability to review the grades that are given for each individual school and for each district, and the Department of Education has the ability to override the judgment of a school or district if its own review of the data shows that the grading is inconsistent with what the state of New Jersey is seeing for a particular school. Viewers are encouraged to review the information available on this website that provides additional guidance on how schools and districts are going to be graded under the new grading system. Another important issue that viewers should be aware of is the issue of Section 504. The U.S. Department of Education Office of Special Education Programs has come out with guidance for school districts on how they need to address the needs of students who have 504 plans, who happen to be involved in sports, athletics, and other types of extracurricular activities. This memo was released on January 25, 2013, and it stresses that school districts must provide equal opportunities for students with 504 plans to participate in all extracurricular activities. Part of that means that we must make reasonable accommodations for kids who have 504 plans in order to allow them to participate in athletics and other extracurricular activities. In this memo from the U.S. Department of Education, one example that was given was a student who was interested in participating in track, in participating as a runner, and a student who happened to be hearing impaired. In this example given by the U.S. Department of Education, school districts should consider providing visual cues for somebody who wishes to participate and do that sort of activity so that they are able to fully participate and are able to be part of doing those activities. That would not, under the U.S. Department of Education judgment, fundamentally alter the nature of the competition for somebody to have a visual cue at the start of a race. Viewers are encouraged to review the full memo that has come out from the U.S. Department of Education outlining what steps school districts should be taking to fully address the needs of students under Section 504. Another important issue that has come up is the issue of school security. School districts have spent a great deal of time addressing school security in recent months. The New Jersey Department of Education recently released a memo on February 26th announcing that school districts may have unannounced drills where they're going to have to focus on one scenario, the active shooter scenario. The New Jersey Department of Education will be spending time reviewing how school districts address this critical issue and has provided a great deal of guidance on how school districts should go about doing these unannounced drills. There was also a memo that came out from the New Jersey Department of Community Affairs on February 22nd that dealt with a particular aspect of school security. This memo dealt with the question of how do we secure classroom doors. A question had been raised by many school districts about whether they could have a mechanism so that somebody from outside a classroom could not open a door and that the door could be locked from inside the room. This memo that came out on February 22nd makes clear that school districts do have the ability, if they follow appropriate guidelines, to have that sort of a locking mechanism within a classroom. Another important issue that's come out is the issue of cyberbullying. Certainly, school districts across the nation are struggling with the issue of cyberbullying. In order to help you have a deeper understanding of this issue, some of the trends that are occurring across the nation on cyberbullying, we're very excited that we have a panel discussion that we're providing for you with two experts in the field. The discussion involves David Rubin, a renowned school law attorney who has a tremendous amount of expertise on the issue of bullying and cyberbullying and has studied the case law on this issue around the country. We also have as a panelist for our discussion Joseph Ventry. Joseph is the Chief Technology Officer for the Monmouth Ocean Educational Services Commission and has a great deal of experience in private industry and in the public schools on the issue of cyberbullying and precautions that school districts can take to address this very challenging issue. We encourage you to view this panel discussion and we will provide opportunities for you to interact with the Legal One team to further discuss this important issue. Hi, my name is David Nash. I'm the Director of Legal Education for the Foundation for Educational Administration and the coordinator for the Legal One program. I'm here today with two guests who are going to discuss the issue of cyberbullying, the legal implications for cyberbullying, and some of the strategies and approaches that we can take to try to help school districts, parents, students address this very, very complicated and difficult challenge. I have with me David Rubin. David is a very experienced school law attorney, has been practicing for many years in New Jersey, representing numerous school districts. He has tremendous experience both in New Jersey and across the nation as a lecturer on school law issues and has chaired the National School Boards Association Council on School Law Attorneys. So thank you, David, for being with us. I also have with me Joseph Ventry. Joe is the Chief Technology Officer for the Monmouth Ocean Educational Services Commission, an entity that provides online training for thousands of administrators, teachers, and students across the state of New Jersey. And Joe is also the founder of the cybersecurityguard.com, an entity that helps to deal with cybersecurity issues for all sorts of organizations. And Joe also has tremendous experience, over 20 years experience working in IT, both in education, healthcare, and in business. So Joe, thank you for being with us.
Sure.
So today we're here talking about the issue of cyberbullying and trying to get a handle on how we address this issue most effectively. So I wanted to begin with a discussion of what the difference is between regular, traditional bullying and what we now call cyberbullying. How are the two the same? How are those two different? And Joe, why don't you start off the discussion?
Well, I would say the major difference, if you think back to before the internet, when you had a case of bullying in school, the incident usually stayed within the walls of the school or whoever witnessed it. With cyberbullying, it brings in a whole new audience, if you will. Not only do the kids who were involved in the school see it, but when it's posted online, anyone can see it. So the exposure for the victim is much greater today than it would have been back in the day before the internet. A student today who was bullied or cyberbullied, and let's say if it's a video or a picture that is not appropriate of him or her, the student could be walking through the mall and have people who they don't know see them, but now these people are pointing and laughing, and this student has no idea why. So cyberbullying, the internet brings a whole different playing field for the exposure for the victim, and it's much, much worse in terms of the impact mentally for the student.
Sure. And as we know, bullying is something that's been addressed by virtually every state in the nation in some way, shape, or form. So we have sort of a layperson meaning of bullying. The term is commonly used by students, by parents, by folks throughout society. But what are some of the things that we need to look for in moving from that lay definition to the legal definition and the specific responsibilities for dealing with bullying on a state-by-state basis?
Well, in the old days, when we thought of bullying, what came to mind is a fight in the schoolyard, 3-on-1. You were able to see who your attackers were face to face. It had a beginning, a middle, and an end. When it was over, it was over. It may happen again. But it was a whole different psychological impact on a child, as Joe pointed out. The difference today is that, and a number of jurisdictions have even dropped the reference to bullying per se. They're calling it really what's more an accurate term, harassment, intimidation, because bullying, like a lot of words in the education field, is a word I think has sort of outlasted its usefulness. It comes with a lot of baggage and imagery that really has been left in the dust in terms of what we're now talking about. And what we're talking about today in definitions of harassment and intimidation around the country tend to focus on several different themes that are important. Number one is that kids can be intimidated and harassed through all sorts of expressional activity, words, gestures. Everything has a context to it, and that's the important theme, is that communication takes place within a context. There are certain neighborhoods where if you walk down the street wearing certain colors, that conveys a very particularized message and a threatening message to other people without even any words being expressed. And depending on the context in which this is happening, that can be as intimidating as if you actually were beating somebody up in a schoolyard. So the first theme is that, and this I think is uniform throughout most of the states, is that it covers communication in whatever form it takes. Number two, I think most of the definitions try to distinguish between what we'll refer to as routine misbehavior or conflict between children, which is inappropriate, needs to be dealt with, may violate a particular code of student conduct in a particular school district, but may not necessarily fit within the definition of the sort of bullying that the statutes focus on. The difference being usually involving a student who just wants to be left alone, who's being pursued, taunted, harassed because of something about that child. Which is the third theme that I see pretty much uniformly across most of the definitions, which is that the definitions in the statutes don't deal with just indiscriminate misbehavior, or it deals with students who are being targeted because of something about that student. Most of the statutes I've seen usually go through the list of protected classifications where a student is being targeted because of race, gender, sex, or what have you, or some other distinguishing characteristic. But the common theme is that that child is being singled out for some particular reason unique to that child. So that is, I think, what sets it apart from the old-fashioned bullying, which is 3 kids beating up some kid in the schoolyard at recess.
All right. And as we know, of course, many states have addressed this issue, and certainly New York State and New Jersey have both taken very, very strong stands in dealing with bullying. New York has put in place the Dignity for All Students Act, which will now include a cyberbullying element as of July 1, 2013. New Jersey has put in place an anti-bullying Bill of Rights that also incorporates the issue of cyberbullying. Can you talk a little bit about how New York is addressing the issue under their new statute compared to New Jersey's approach?
Well, I see really more similarities than differences. The terminology is somewhat different. The definitions are a little different around the edges. But I think the common themes that I see between the two of them is that, first of all, there's a very heavy emphasis on prevention and school climate. There's a lot of talk about apprehending violators and imposing consequences, but that's really the tail wagging the dog. The primary emphasis in both states is on improving school climate, because everyone realizes that once you can get to the point where the students themselves find this behavior unacceptable, that'll be the measure of success. So heavy emphasis on training, heavy emphasis on prevention. What is in common between both states is a lot of a data-driven process now, much more so than there used to be, because the idea is that in the old days, even as school administrators treated each incident properly, investigated a matter by the book, gave out disciplinary consequences if it was appropriate, then went about their business until the next complaint came along. We realized over the years that we were sort of missing the forest by focusing on the trees. And it wasn't until a number of major cases came along that taught us that you really have to focus on the school climate up front and take preemptive, proactive measures to improve the school climate. That's really how you're going to deal with this. And if you don't do that, then it really doesn't matter if you effectively investigate it as it comes along, because you've already missed the boat. So I think that's the main focus of both statutes, and most of the others I've seen as well, is to focus on improving school climate to begin with, so that hopefully you have fewer incidents to investigate and dole out punishment for later on.
Sure. Joe, what are some of the challenges involved in trying to address cyberbullying? What makes this a more complicated issue to sort of get to the bottom of and figure out how we can stop it?
Well, part of the issue is for a school district to actually, let me back up. It's easier for a school district to track this down if it's happening within the school using the school computers,
Sure.
because they have mechanisms in place that track where students are going and things of that nature. Where it gets difficult is when it's outside of the school and the multitude of devices that can be used to harass a student, to bully a student through the internet. So in addition to that, the anonymity part of the internet. Sure. You know, I'm not going to go on the internet as Joe Ventry and say David Nash is whatever. I'm going to, you know, I don't want you to know it's me, so I'm going to try to create a second identity and try to go through it that way. And once you get into that, you need a little more expertise to come in and track it down, because it's not as easy, it's not as obvious for the lay person to go in and figure out, you know, where did this come from and who actually said it. But it can be found. It's just that you need the technical expertise for someone to come in and do some type of forensic investigation into the systems that may have been used by the student to do the bullying.
So along those lines, if a student is being anonymously bullied online, what would be some of the specific steps you could take to try to track down who the bully is? Can you actually work with the internet provider in order to try to track down that student?
You can only go so far with the internet provider. I've had experience with this even in the corporate world, where we were receiving emails from a former employee who didn't like that she was fired, created a fake email address and was emailing the VP and the CEO. I was able to trace it back to a specific internet provider, but the provider said, if you want to know who this is, you need a court order, because there's privacy laws that are in place.
Yes.
So that usually ends up becoming the stumbling block for, again, it depends on how far the corporate world wants to take it. Now, in our case, they don't want to waste the money. You know, they said, we're not going to go with the attorney, just block the email address and let's be done with it. In a school district, that's always going to be the case. You know, they're always going to want to take the path of, you know, let's not spend too much money on this unless it's something very serious. But they're not going to go the route of getting a court order or getting an attorney involved when they can just say block the email address and be done with it.
One of the issues that school districts have to deal with, of course, is sometimes partial information, incomplete information regarding cyberbullying. So one issue that often comes up is that you'll have one parent or one student come to a principal and show a printout of something that we might agree is cyberbullying, and now the parent or student demands that you do something about this and punish the alleged bully. Are there some pitfalls in responding to that immediately, in trying to take action when you have that sort of information coming regarding cyberbullying?
Well, there are two challenges I think that administrators are going to face. One is staking out what his jurisdiction is as far as reaching behavior that happens off campus after hours. There's a general consensus that school officials have not only the right but at times the obligation to deal with behavior that happens off campus after hours if it has a direct effect on the school community, if it's behavior that affects a student's ability to come to school and feel safe during the school day. Typical example, two students sending each other instant messages at night about who's going to do what to whom at recess the next day at school. That'd be an example of a threat that would have a direct impact on the school community. There may be other communications that have nothing to do with the school community, that may be hurtful or perhaps threatening to that student, but have nothing to do with the school experience. So the first thing that administrator would need to do is be very clear on what the outer limits of his jurisdiction are. The second challenge he would face is whether that communication that comes in on that printout may well be protected First Amendment speech under case law around the country that gives students a fair amount of freedom to express themselves on matters that may be hurtful, insensitive, insulting to other students, where it's a protected constitutional right to do that and not something that can be punished. Everybody agrees that where somebody on the receiving end would take that communication to be a threat of physical violence by some objective, reasonable standard, everybody agrees there's no protection for that. But there's a lot of stuff going on the internet communication among students that may be hurtful and insensitive that can't be touched because it's protected.
Sure. And of course, one of the things we have to look at is whether or not the behavior is causing substantial disruption. Sometimes there are disagreements between kids that are just typical conflict that you have between students, and it's not always to the point where it's causing substantial disruption or interference for the student who's being targeted. So I think my sense is that sometimes a parent might only have part of the story, the part that their child is willing to share, and it's possible that you really have two students who are engaging in some sort of a mutual conflict where there are comments going back and forth. So I would think it's fair to say we want to make sure we have full information before we act. Usually if there's one printout coming from one parent, there's probably a very good chance that there's some additional information that might involve the other student responding.
Well, if there's one thing we've learned in this field is that nothing happens for no reason. It may not be a good reason, but there's always some reason.
Sure.
Things don't happen in a vacuum. So if someone is on the receiving end of a comment, it's rare that it comes completely out of the blue. There's usually some act or event or some perceived grievance that somebody has that precedes that may at least explain, if not excuse, what's going on. And often, you're correct, you find out that there's really an underlying conflict between two students, and it's not within the definition of bullying or harassment that the statutes are designed to target, which involves typically a student who's just looking to be left alone, who's being pursued and taunted without having provoked anything.
All right. Let's sort of take this to the next level. Now let's assume that we have a situation where we all agree a student has been the victim of harassment, intimidation, or bullying. And we agree that it meets the state's definition of cyberbullying. And now we have to address both the bully and the victim. What are some of the key principles we want to keep in mind when we're talking about the victim? I mean, unfortunately, we have seen some high-profile cases around the country where victims of bullying have attempted, or in some cases even committed suicide. What are some of the common sense steps that school districts want to take when they do have a victim?
Well, I think the most important thing is to make sure that you're providing support to, not to the victim, of course, but not just the victim. We find oftentimes that the student who we're regarding as the offender may have issues of his or her own. We find that oftentimes people who are engaging in this behavior many times have been the victims of bullying themselves. And there are some studies that have indicated that somewhere in the area of 5% of kids are both victims of bullying and also offenders themselves. And those students may need issues, may need have needs that may need to be addressed, that need to be focused on as well. But certainly the uniform position of the states that have addressed this through legislation is that the victim needs to feel protected, needs to feel supported, and there are ways to do that that may not necessarily involve punishment of the offender. Sure. It could involve something as easy as rearranging seats on a bus. It may be something as easy as providing counseling or just helping students who may come from different backgrounds or cultures understand how to speak to each other in a way so that it can avoid misunderstanding. So it's not just about punishment, but the clear common denominator of all of these statutes is creating an environment where the victim can feel safe in coming to school, and that is paramount.
You know, we had a high-profile case decided by the Second Circuit Court of Appeals, Zeno versus the Pine Plains Central School District, and this was a case that was brought under federal anti-discrimination law. And it was a case where the school district was found to have some liability. Can you talk briefly about that case and some of the lessons that we might learn, even though it was not brought under the Dignity for All Students Act, New York's bullying law?
Well, as I recall, that case dealt with the issue that the federal courts have been dealing with for many, many years, well before our bullying statutes came on the books, and where children were being subjected to all sorts of of violence and harassment. And the courts have been struggling for decades to come up with a legal theory to deal with that. Some people argue that if something happens at school, school districts have strict liability for anything that happens. Other courts have argued that that is unfair because you can only hold school administrators accountable for what they knew or should have known about. And over the years, a number of federal courts had come up with a standard that is referred to as the deliberate indifference standard. It's a standard that says school administrators can't be held responsible for everything that happens in the school. You can only hold them accountable for what they know or should have known about. But if all the signs are there and school officials turn a blind eye to all of the dots without looking to connect them, that it's sort of, I don't know and I don't want to know, where it gets to that level, courts, and including the court in the case that you've described here, have said that that is almost as if you were responsible. You take ownership of it if you are deliberately indifferent to the clear likelihood that misbehavior and bullying is going to be happening. And in the case you mentioned, it was very clear in the record there that that school district actually did a lot to try to deal with the bullying once it found out. The problem the school district had in that particular case is they were a little late to the game, at least according to the record that's in court, and we all know that sometimes what really happened is not necessarily reflected in the court record, but if that's all we have to go on, there are a lot of preventive activities and school climate enhancements that the school district brought to bear once it learned that this student who started being harassed as a freshman brought it to light. But by the time the student was a junior, after 2 or 3 years or more of this harassment, a jury found it was too little too late. And I believe the school district in that case was hit with a verdict initially of about $1 million and a quarter. And the federal judge reduced it down to about $1 million. But the point there is that there's serious, not that that's all we should be concerned about, but it's a cautionary tale for those school districts who feel that it's not cost effective to be spending a lot of resources on preventing this. Here's an example of what can happen when you don't.
Sure. So certainly if we find a potential liability in a case like this of $1 million, where it is somewhat challenging to show deliberate indifference, I think that's a very important signal for actions that could be brought under the Dignity for All Students Act.
Absolutely. As far as spending money on preventive resources, here's an example of how expensive it can be when you don't prevent this sort of behavior.
Absolutely. Joe, can you talk a little bit about strategies for school districts to work with students and parents to try to help deal with this issue, to raise awareness, to help prevent and address the issue of cyberbullying?
Sure. I think one of the things that needs to take place, and I've actually spoken about this in a few lectures, is part of the computer classes that take place today, part of that class needs to be informing students about their online identity and the impact that identity can have on them in the future. I mean, we've heard on the news lately where people are going on interviews and not getting jobs because the potential employer does a search on Google of the potential employee and finds material that they find objectionable, whether it be on Facebook or Twitter or what have you. So I think students need to be made aware of that. I think that would have some impact on, so that when they're online and they're about to post something, maybe they'll think twice about it, because nothing ever goes away online, as we all know. I mean, once it's out there, it's out there. It's one of the questions I always get is, from parents is what can I do to my computer to prevent the cyberbullying? And unfortunately, there isn't a piece of software or there isn't a button to hit. It's actually more prevention before you even get to the computer, and getting the student and getting everyone involved to understand the impact that cyberbullying has, words have. I like to say that teasing has been taken up a notch because of the internet.
Yes.
So students need to be made aware that their words don't disappear once they're online, and parents need to be more involved. They can't have the attitude. Another thing that I hear a lot of is, oh, my son or my daughter knows more about that than I do. And no one's saying a parent has to become a IT expert, but be involved, get involved. Look at your son or your daughter's Facebook page. If you're not sure what should or shouldn't be on there, because sometimes it's not obvious. Sometimes I've seen a lot of parents do this. They'll put pictures of their children online, and they'll have their profile settings on Facebook set incorrectly so that anyone in the world can see it. And if you look at some of these pictures, you'll see some identifying attributes. For example, one had a picture of her 5-year-old daughter, and she's wearing a sweater with the logo of her school. So now I know where that child goes to school, and in terms of, you know, stalkers or pedophiles or what have you, that's just not good. You want to have that information protected. So it's like the old saying goes, knowledge is power. The more informed they are, the more they can pass that along to their kids. And again, schools should build it into the curriculum, you know, because Web 2.0 is here. It's not going to go anywhere. Trying to, you know, if you lock it out so that they can't get to Facebook in school, fine. I mean, so a lot of schools do that, but they're going to go home and do it. So make it part of the curriculum. You know, tell them when you post things online, this is what you're putting at risk. Perfect example would be Facebook likes to ask for your date of birth and where you were born and things of that nature. But as an aside, if you create an account with a bank and they ask you to set up security questions, those questions are, where were you born? What's your date of birth? So now you have it posted publicly, but these are supposed to be your secret questions so that you can get your password unlocked, so you can get access to your information, so your banking. I think it helps to show the students some of the cases that have taken place where students have committed suicide. There was a recent case, it escapes me where it was, but a 13-year-old boy committed suicide because he was being teased. A girl in Canada committed suicide. She actually, what's very tragic is she attempted suicide and was not successful because she was being bullied online. And what had happened was she was in a chat room. Somehow the person she was chatting with convinced her to remove her top. He took pictures, still shots of her topless. Later on threatened that if she didn't do it again, he was going to post it. She attempted suicide. She wasn't successful. She did a video about how serious it was. She was on YouTube. She got a little bit of press on it, but it didn't go away. The issue didn't go away. She killed herself. So, you know, students need to be made to understand the impact that, you know, there was a time when calling somebody a name, it would go away. Online, it doesn't go away. It's always there. So, and the other thing is that pylon factor. You know, there are so many people that this is exposed to.
Sure.
You know, you see it, you think it's funny, now you send it to me. I have absolutely no connection to this girl, but now it's been, and then I'm going to send it out to him, and you know, it expands and expands, and the exposure is just, that's what I think brings a lot of these kids to that point, is knowing, because in a lot of cases they do think a lot differently than the adults. They know how far this is going to go, and that's what bothers them. That's what brings them to that point.
We should say along those lines that suicidal ideation is a very complex issue. Bullying is one factor that increases the risk, but there are multiple factors involved in the issue. And I know sometimes the media tends to oversimplify that issue. So it's a complex issue that involves a wide range of factors, and certainly students who have other issues going on, if you add in a bullying element, can be the thing that tips them over the edge. But I just wanted to point out that that is a complex issue that involves a lot of factors.
The one thing I just wanted to add to what Joe was saying was that adding to the psychological trauma of cyberbullying is that we like to think of our homes as safe places to be. And the one thing that makes cyberbullying different than old-fashioned bullying is that here you have people invading your home, if you will. A student is sitting in her bedroom at night, and here are essentially people coming into her home, appearing on a screen, unknown, anonymous, and the invasion of a place that you traditionally associate with safety, I think, adds to the psychological trauma of cyberbullying that, to answer your earlier question, makes it different from old-fashioned bullying where you confronted the perpetrator face-to-face, you knew who they were, you knew where this was happening, it happened within a circumscribed area. So that additional factor, I think, adds to the psychology of it all. One
final question. We're going to give you the last word, David. When you're thinking about developing a school district policy on the issue of cyberbullying, what are some of the key elements that we should look to include in that? Is this an issue that is important for all staff members to be involved in, or is this really just focused on the principal and a small group of staff?
Well, I think if there's one common denominator, again, among the statutes I've seen around the country that deal with this, it's first of all to have a policy that defines as clearly as you can what the permitted behavior is and what's prohibited. Because if you just speak in generalities, a policy isn't worth the paper it's written on. Now, that's challenging to do because, as I said before, we have to balance protection of students' rights to express themselves on the one hand versus protections that other students are entitled to so they're not subjected to a hostile environment. But the starting place is a policy that's worded as clearly as possible, that everybody, including staff, have had input into, so that it reflects the culture of that particular school and that particular community. Because, you know, what is acceptable in one community may be unacceptable in another, and it has to really reflect the tolerances of the particular community. The other thing that's very important is that policy has to be disseminated in a way that students and the community have access to it, that parents have access to it. A policy, again, isn't worth the paper it's written on if it's collecting dust on a shelf somewhere. So those are the two key ingredients, is to have a definition that is understandable so people know what the dividing line is as best as we can spell it out, and to make sure that it's accessible to people through being posted on a school district's website and any other way you can to make sure that it's there. And then thirdly, people should know where to go, whom to go to if they have a problem. That bottleneck itself has resulted in liability for a number of districts where the policy's been fine, people knew about it, but they didn't know whom to call.
And is it fair to say that sometimes the key staff member might be the secretary, might be the custodian, might be the bus driver who happens to see that there's an issue going on? It's not always going to be the school principal or the guidance counselor.
Actually, it's more likely it's going to be one of those folks, because where is this happening? If it's not happening online at home, it's happening in unstructured settings in school. It's happening in the cafeterias, in the hallways, on the buses, places. It's not happening by and large in the classrooms where the teachers are and where the certificated staff are. So in my experience, these other areas are more likely to be the venues where it's going to be happening. That's why the philosophy is we have a lot of adults on the ground, whether they be a custodian, whether it be a teacher, whether it be a bus driver, and it's like from the Homeland Security posters we see. If you see something, say something. The idea is that if all the adults in the picture keep their eyes and ears open and report what they see, we're not going to miss too much.
Great. All right. Thank you, Joe. Thank you, David. This has been a wonderful discussion. I appreciate all your words of wisdom. I think it'll be very helpful for folks in understanding and dealing with this very complicated issue. So thank you very much. We encourage viewers to look for future editions of School Law TV. We are going to be providing information on the latest developments in school law on a number of topics. Each month we will provide a new issue of this important show, and each month as part of that we are going to give you a panel discussion with persons who have great knowledge in different areas of school law. All of this will be available on Legal One's YouTube channel. We also encourage you to go to Legal One's website for additional information regarding this programming. Thank you very much for joining us for our premiere episode.